Hey, good morning, everyone. For those of you that do not know me, my name is Norman. I'm the president of Singapore Business Group. And we're very happy today to co-host this morning's webinar together with Bizlink. If you have seen the EDM that we sent out, the topic for today's webinar is the Vietnam New Law on Investment 2020 and Law on Enterprises 2020. Right, the objective for this morning's webinar is to share the major changes of the Vietnam New Law on Investment 2020, Law on Enterprises 2020, and their impacts on foreign investment and businesses in Vietnam. Together with us, we have 7 co-host chambers, not in any particular order. Let us welcome members from the French Chamber of Commerce and Industry in Vietnam, the Council of Taiwanese Chambers of Commerce in Vietnam, Hong Kong Business Association Vietnam, Italian Chamber of Commerce Vietnam, Indian Business Chamber in Vietnam, Malaysia Business Chamber Vietnam, last but not least, the Thai Business Association Vietnam. So let me walk through you the agenda for today. After my introduction, we will pass it on to Bizlink. The introduction and keynotes will be done by Mr. Trong, and the highlights of New Law on Investment 2020 will be done by Ms. Lê Thị Hồng and Ms. Lê Thu Thao, and they will continue with highlights of New Law on Enterprises 2020. Then we will follow by a Q&A, and we should end the webinar at about 11:30. So without further ado, let me introduce to you the 3 speakers that we are fortunate to invite for this webinar this morning. First, we have Mr. Trong, Managing Partner of Bizlink Lawyers. Mr. Hai, the Managing Partner of Bizlink Lawyers, is well known and rated by many international legal publications for years as a leading lawyer in Vietnam. With over 25 years of law practice, Mr. Hai has acquired broad and extensive expertise and experience with a focus on foreign and domestic investment, corporate and commercial, M&A, real estate and construction, dispute resolution, banking and finance, and etc. His high-ranking position has achieved through his valuable and business-oriented advice and assistance rendered to hundreds of clients as foreign investors and businesses from many countries around the world. Next, we have Ms. Lê Thị Hồng, Senior Counsel of Bizlink Lawyers. With over 10 years practice, Ms. Hồng has gained vast in-depth experience in supporting foreign and domestic projects, companies of different sizes and industries. Many of her clients came from Singapore, Japan, Korea, Malaysia, China, Hong Kong, Australia, and France. During her career span, Ms. Hồng has made great focus on and has been highly appraised by clients and peers for her knowledgeable advice and practical solutions on foreign and domestic investment, mergers and acquisitions, corporate and commercial. Her lawyer representative clients include the largest motorbike and car manufacturing joint venture in Vietnam. And last but not least, we have Ms. Lê Thu Thao, Associate of Bizlink Lawyers. Ms. Thao is a Hanoi-based associate of Bizlink Lawyers with 5 years of working experience. Ms. Thao's general practice areas cover corporate governance, foreign and domestic investments, employment, trade and competition law, and M&A, while her specialty is on corporate governance, business setup, and licensing work. Her knowledge has sharpened thanks to her deep and active engagement in the team advising foreign investor companies in Vietnam, with the source of investment from Singapore, Japan, and Taiwan. Our team's representatives retaining clients include the top cement production joint venture in Vietnam. So there you have it. Our three very experienced speakers for this morning's webinar. And before we pass on the microphone, so to speak, to Mr. Hai, we would like to thank our national corporate sponsors of Singapore Business Group, which are our platinum sponsor, Capital Land, diamond sponsors, UOB and VSIP, silver sponsors, KPMG, Full Matrix Specialist Industrial Park, and Hammock Hotel. So now, without further ado, I'll pass on to Mr. Hai to start the webinar this morning. Thank you, everyone. Mr. Hai.
Thank you very much. Thank you very much, Mr. Norman Lim, for your introduction. And taking this chance, I also would like to thank for the collaboration of SBC, EXCO and staff, and also other associations to host and co-host in this event. So before going to present the new changes on the new law on investment and new law on enterprise 2020 by my colleagues, Ms. Leti Hong and Ms. Thao, I would like to make some highlights on the new improvement and achievement of Vietnam in the recent year, and especially in the first 9 months of 2020. The first thing that in terms of the agreement between Vietnam and many other countries, you can see that in the past some years, the government of Vietnam has tried to negotiate and sign bilateral treaty and agreement with many countries in the world. So also, as a member of the ASEAN, Vietnam has become the party to a number of free trade agreements where ASEAN is a party. So, especially in the last 3 years, you can see in the table that Vietnam has made a great achievement in signing and implementing the comprehensive and progressive agreement on Trans-Pacific Partnership. So in short, the TPP. So in Vietnam signed that agreement with another 10 countries in March 2018, and that agreement became effective for Vietnam since 14 January 2019. As a member of the ASEAN country, Vietnam became the party of the ASEAN-Hong Kong Free Trade Agreement, as well as the ASEAN-Hong Kong Investment Agreement that both were signed in, on 12 November 2017 and became effective in June 2019. Very important is that the recently in 2019 June, Vietnam signed the free trade agreement with the EU, so-called EVFTA, and also the investment protection agreement. The first EVFTA already became effective from the 1st August 2020. That brings a lot of opportunity for Vietnamese goods and services to be exported and imported within this within the Vietnam and Europe 27 country member of Europe. So that is the achievement of Vietnamese government in signing the treaties, free trade agreement, especially the model free trade agreement with the important market. And in terms of the local domestic policy, domestic law, the government of Vietnam, and as you know, the government of Vietnam is controlled by the one party. We have the one party controlling the government, and the Politburo is the highest authority of the Vietnamese Communist Party. And in 2019, the Politburo of Vietnam Communist Party have already issued the resolution number 50. And following that, the government of Vietnam issued the resolution 58 in 2020, in April 2020. So in that two important documents, the party and also the government set out, make the orientation on the foreign investment, on the reconfirm the importance of the foreign investment into Vietnam, and set out the policy, the main policy for invest to improve the investment into Vietnam by the following. The first one is it set out the priority in promoting the technology and cooperation and transfer. The second, attract the foreign investment, FDI inflows for establishment of R&D and innovation center in Vietnam, and support and promote supporting industry, startup innovation, enhance the technology absorptive capacity in technology autonomy, and participation in the global economic value chain. The fourth priority is to protect the environment, natural resources, and conserve energy. The policy also show that the government of Vietnam would not encourage to grant the expansion or extension of the project using out-of-date technology and potentially causing the environmental pollution and resource incentive. So this policy under two documents have the, that is the policy and the priority set out by the government for implementation in the next 10 years from now until 2030. So the next highlight in the next slide, I would like to provide you with some very short and important highlights. That even though the COVID-19 pandemic, the spread of that pandemic around the world and all the countries have been seriously impacted, but Vietnam, the very good thing that Vietnamese government and people have tried to fight against this pandemic, and even though it has been impacted and adverse to the economy, but in the first 9 months, the figures of the FPI, the Ministry of Planning Investment, show that we have the encouraged result. So in terms of the foreign investment inflow into Vietnam, in that first 9 months in 2020, we have the total invested capital from the foreign investor is 13.76 billion US dollars. So the total registered capital, in terms of the total registered capital, we have the newly registered capital of 10.36 billion, slightly decreased by 5.6% of the same period last year. For additional registered capital, we got 5.11 billion US dollars, increased by 6.8% compared to the same period last year. This is very good, signal that we even get more the volume of investment in this additional registered capital compared with the last year, even with the pandemic. So for the registered capital through the M&A transaction, we have 5.73 billion US dollar. So decreased by 44.9% of the same period last year. So in terms of the total number of projects, so we have the total newly registered project of 1,947 projects, decreased by 29.4% of the same period last year. So total number of projects registered for increase of capital, we have 789 projects, decreased 23% compared with the same period last year. And finally, the total number of M&A transactions, we have 5,172 transactions. So decreased by 20.5% of the same period last year. So in the next slide, you can see that in terms of the source of investment, foreign investment, you can see that we have the three leaders, leading investors to Vietnam in the last 9 months. So in which Singapore ranked number one with 6.77 billion US dollar total investment capital, accounting for 32%. And following that, Counsel is with 3.17 billion US dollar, accounting for 15% of the total investment capital. And China ranked third with 1.87 billion US dollar, accounting for 8%. In terms of the number of projects, Singapore, with the relative small number of projects, even though the total investment capital is high. So Singapore have 170 projects. Meanwhile, South Korea have 499 projects, and China ranked second in terms of the number of projects. They have 271 projects. So that is all of my highlights on the recent achievement and improvement of Vietnam. So I will pass on the microphone for my colleagues, Ms. Lady Hong, to present with you on the investment law. So Ms. Hong, please.
Okay, thank you, Mr. Hai, for your introduction. So, hello, today I'm very happy to share with all of you about the new law on investment 2020. And as we know that the new law on investment 2020 will come into effect and replace the current law on investment 2014 from the 1st January of 2021. And because of the time limit, so today I will focus only on these 9 major changes of the new law. First, exception for setting up new companies. Second, change the major ownership ratios definition. Third, registration for purchase of share capital. And 4, conditional business lines. 5th, investor selection. And 6th, delegation of authorities in approval for investment policy. 7, adjustment of projects. 8th, extension of project term. And 9th, investment incentives. A good news about setting up for the foreign investor. That is about exception for setting up new companies. As we know that according to the current law, if the foreign investor desire to set up a company in Vietnam, they are required to apply for 2 licenses. First, investment registration certificate or IRC, and the second is enterprise registration certificate or ERC. But according to the new law, there are exceptions. So if the foreign investor set up the small and medium-sized innovative startup enterprises or innovative startup investment funds, they are not required to apply for IRC. It means that they only require to apply for ERC. So this new regulation brings the great benefits for the foreign investor. Significantly reduce the amount of licensing work and save the foreign investor a lot of time, because we know that according to the law, in order to apply for IRC, it takes about 15 days. But from my experience, it may take at least a month for the time to prepare the documents and also to submit the data to the competent authority. So actually, this new stipulation is inconsistent with current policy of Vietnamese government to support for the innovative startup. And from our observation, recently, there are many startup, especially from Singapore and Korean, invest into Vietnam. And with this new change, we expect to have more startup coming into Vietnam in the near future. Okay, next. About change of the definition on major ownership ratio. The law on investment and law on enterprises 2020 have a change to the definition of major ownership ratios. And I will give you an example. Actually, this change is reflected in several stipulations of the new law on investment. And today I will give you an example. For example, to set up a new company or purchase share capital or invest under the form of BCC, the foreign invested company with the foreign ownership ratio from 51% or more are required to certify the investment conditions and follow the procedure applied to foreign investor. So now the requirement and conditions are the same, but the ownership ratio has been changed from 51% or more to over 50%. And these changes will also be presented in the next part later on. Okay, I move to the next. Registration for capital contribution or share capital purchase. As we know that normally, according to the current law, if the foreign investor increase their capital contribution or they buy shares or capital in a company in Vietnam, they have to register for capital contribution or share capital purchase. And this procedure simply called pre-approval. And then IRC or ERC may be amended, subject to XK. And the change of the new law focus only on the pre-approval procedure, especially for the cases that require to conduct this procedure. I will go through the each case. First, about investing into a company conducting the conditional business license. So according to the current law, if the foreign investor invests into a company in Vietnam conducting the conditional business line, they are required to conduct the pre-approval procedures for all cases. But according to the new law, the pre-approval procedure will be only required just only in the case that the investment makes the foreign ownership ratios in that company increase. So here I give you an example. A joint venture between Vietnamese party and Singaporean investor with the foreign ownership ratios is 30%. And now if the Singaporean investor transfer all of their capital to a Malaysian investor, so in that case, because the foreign changed, So it means that under the new law, pre-approval will not be required. But if Vietnamese party transfer 10% to the Malaysian investor, so in that case, because the foreign ownership ratios increase from 30% to 40%, so it means that under the new law, the pre-approval will be required. Under the current law, for these both two cases, the pre-approval will be required. Here's the new law and the current law. I move to the next. As I already mentioned, the change of the definition of major ownership ratios is also reflected in the requirement for pre-approval. And here you can see, for example, in case that foreign investors invest into a company in Vietnam, that make the foreign ownership ratios increase from under 51% to 51% or more, or from 51% or more to a higher ratio. So the pre-approval will be required. So here, now, according to the new law, the requirements and condition is the same, but the foreign ownership ratios have been changed from 51% to 50%. And here is the new requirement under the new law. If the foreign investor invests into a company in Vietnam that has land use right certificate for land on islands or in border coastal communes or in other areas affecting national defense and security, so pre-approval will be required in this case. Actually, this new requirements is for the purpose of tightening the state control over the foreign investment in the areas that affect national defense and security. So for this part, please note that the foreign investor will be required to conduct this procedure regardless of whether the company in Vietnam has office or conduct business on that areas or not. Okay, so that I finished about the pre-approval, and next about conditional business license. Under the new law, the number of conditional business license has been decreased from 267 to 227. And for the conditional business license that has been changed this time, we divide them into 3 groups. The first group includes the ones that has been removed from the current list. And there are 3 reasons for this removal. First, because some of them are not considered as business license in nature. For example, arbitration services, debt trading, franchising. And the second, for some of them, it's better to manage the product quality standards instead of business line, such as motorcycle helmet trading or food trading. And the third, for some of business line, it is not under the current situation, it is not necessary to manage at the conditional business line. The second group, including the one that has been amended. And the reason for this mainly is for consistency with other relevant regulation, especially for terminology consistency. And the last includes the ones that has been added to the current list. There are 2 reasons for this. For consistency with other relevant regulations, such as architectural services, imported newspaper distribution services, and for the second reason, for security and safety use of information data on the internet and in electronic transactions, such as data center services, electronic identification, and authentication services. Okay, we have two new abandoned business lines, trades in firecrackers and debt collection services. Next, I think this is a very interesting part. Selection of investor for projects. So we know that currently, for the projects that need to have an approval from National Assembly, the Prime Minister, or Province or Pupil Committee, these agencies will issue decisions on investment policy. But now, according to the new law, this agency will issue an approval for investment policy. And the difference between these two is that the decision will record detailed information about the projects and also about the investor of the project, while the approvals just record some information. For example, the approval will record detailed information about investor or just record the form to select investor. So accordingly, there's also a new stipulation in the new law about form to select investor. And there are three forms to select investor. First, holding land use right auction, which will be conducted under the law on land. The second, bidding to select the investor, which will be conducted under the law on bidding. And finally, approving the investor. This new stipulation is for consistency with other laws and regulations, and also create a legal ground to select of the project investors. I move to the next part, delegation of authorities in approval for investment policy. The changes of the new law focus only on the authorities of the Prime Minister or PM and the authorities of the Provincial People's Committee or the PC. And in general, the scope of authorities of the PM has been narrowed, while the PC has been expanded. So I go to the part, the first about the PM authorities. So here, first, according to the current law, all the projects for construction and operation of airport or seaports will be under the authorities of PM. But now, according to the new law, only certain types of this project will be under the authorities of PM. And the PM will only have authorities to approve for the newly granted projects. Second, currently, the betting and casino services will be under the authorities of PM. And now, under the new law, the projects for prize-winning electronic games for foreigners has been excluded from the PM's authority. Next, there are three types of projects that has been removed from the authorities of PM. First, project with investment capital of 5,000 billion VND or more. This is because now the PM's authorities will be based on the project types only, but not based on the capital. The second, the projects for petroleum exploration or extraction, because this types of project will be managed under the law on petroleum. And the third, the project for cigarette production, because Vietnam is a member of WHO Framework Convention on Tobacco Control. So for that reason, from now on, there will be no news. The cigarette production will be granted. Okay, and here's finally the project for construction and operation of golf courses has been delegated from the PM to the PC. And here some projects that has been expanded from the authorities of PM. The project falling within the authorities of 2 province or PUSO committees or more, and some certain types of projects on construction of residential housing of urban areas. Next, about the authorities of the PC. Here are some as I already mentioned, the authorities of PC has been expanded, and here are the projects that will be under the authorities of PC under the new law. First, some certain types of projects on construction of residential housing and urban areas. So now you see that for these types of projects, it will be either under the authorities of PM or PC here. The second, as I already mentioned, the project for construction and operation of golf courses has been delegated from the PM to PC. And next, as I already mentioned once before, the projects of foreign investor or foreign invested company on islands or on border coastal communes or on other areas affecting national defense and security will be under the authorities of the PC. And the purpose of this new requirement is for tightening the state control over the foreign investment in the areas affecting national defense and security. This is consistent with the recent policy of the Vietnamese government, as Mr. Hai already mentioned. And next, this is the same as the current law. Projects that you land allocated or let out by the state without auction or bidding or transfers. Projects that require changes of land purposes. But for that project, is it conducted under the new law? If it's conducted by family, household, or individual, it will be excluded from the PC, province or people committees. Next, the project using technology is restricted from being transferring, has already removed from the new law. So we can see that by narrowing the authorities of PM, it means that the PM authority has been delegated to the PC and other lower state agency in approval in foreign investment policy. And by that way, in our view, the investment in some types of project would be easier in practice, at least for investment procedures. And here I move to the next part, adjustment of project regarding project implementation schedule. In a project, we can have the project implementation schedules. It means that, and this will be recorded on the INC or decisions on investment policy and now approval for investment policy, if any. So this is the schedule for capital contribution for construction of factories or building and put the buildings or factory into operation. And according to the current law, the procedure for extension of project implementation schedules is quite simple. The investor just needs to submit the application and then the state agency will issue the written acceptance. It's quite simple, more than the project adjustment procedures. But now, according to the new law, if the investor desires to extend the project implementation schedules, so they have to follow the procedure for project adjustment. And this new requirement is for consistent about procedures, investment procedure in practice. under the law. Okay, I move to the next. Extension project. And here's the good news. I will go to this point by taking an example for you. If the project term if the current project term is 20 years, and so in that case, under the current law, the investor, I'm sorry, just give me a moment. So according to the current law, the investor will have right to apply for extension up to the maximum of 50 or 70 years. And now under the new law, not only that, but if after expiry of the maximum 50 or 70 years, the investor will have right to apply for an extension of the project term for an additional terms of maximum 50 or 70 years. And this will have exceptions. Project using obsolete technology, project causing environmental pollution, or natural resource intensive projects. And the second, the projects that investor must transfer access to the state of Vietnam or Vietnamese party without refund. And with this new stipulation, it creates a clear legal ground for extension of project term after the maximum of 50 or 70 years. Next, finally, about investment incentives. Under the new law, there are additional projects that will have enticed to enjoy the investment incentives. And I list here some types of projects. First, startup projects, innovation centers, research and development centers. Second, the projects that involve into the investment activities to support small and medium-sized enterprises. Next, the project involving transfers of technologies encouraged to transfers and also others. And finally, the social project for social housing constructions and project that employ the disabled persons. So with that, I conclude. Here's the conclusion of my part, and here's seven key takeaways for you. First, exception for setting up new companies. Second, registration for purchase of share capital. And third, conditional business lines for investor selection. And fifth, delegation of authorities in approval for investment policies. Sixth, extension of project term. And seven, investment incentives. So with that, I finished my part, and thank you very much for your listening. And now I would like to invite Ms. Thao to take over for me to continue with the presentation about Law on Enterprises 2020.
Following our Ms. Hong, I would like to continue with changes in Law on Enterprises 2020. First of all, I would like to thank you for your time and your participation in our webinar today. For over 5 years of application, despite some considerable and positive improvement compared to the Law on Enterprises 2005, the Law on Enterprises to 2014, however, has relieved some shortcomings arising from its practical applications. Recently, the Law on Enterprises 2020, which will come into effect from 1st January 2021, has been adopted to address such shortcoming and so difficulty for businesses. Well, due to the time limit, we will, due to the time limit, we will present some relevant highlighted amendments, which in our opinion will impact on business activity in general, as well as specifically on foreign investor and foreign invested companies. Well, for your ease of reference, I would like to divide such amendment into two sections, consists of enterprise establishment and corporate governance. In the sections of enterprise establishments, I would like to point out two major changes that are amended by the Law on Enterprises 2020, which are amendment to the time limit for capital contributions and amendment to the seal of the enterprise. Regarding the time limit for capital contribution applied for companies which are newly set up, currently the time limit for investor to contribute charter capital is 90 days from the date that the enterprise registration certificate is issued. Well, practice has shown that for some cases, for example, if the contributed access are the rights to use lands, or the machine access are the machine which is imported overseas, such deadline will be very difficult to comply with, and sometimes it is impossible to comply because the time to conduct administrative procedures to transfer ownership of property or the time for transportations and import of such access will even sometimes take more than 90 days. Therefore, the Law on Enterprises 2020 has amended these provisions. Accordingly, the time for transportations, import access to be contributed as capital, and the time for conducting administrative procedure to transfer the ownership of the property will be excluded in the time limit for capital contributions. Moving on to the next point, I would like you to join me in a Q&A as follows. The question would be, shall the seal of the enterprise solely exist in the physical forms? Well, as you may know, currently the seal of the enterprise shall solely exist in the physical form, which is made at stamp engraved establishment. However, after 1st January 2021, according to the Law on Enterprises 2020, the seal of enterprise shall also be in the form of digital signature, which is in accordance with the Law on Electronic Transactions. The seal form of digital signature is a major reform of the Law on Enterprises 2020, which is in line with the business, with the world developments, because now business transactions and administrative procedures have been increasingly conducted on the internet. And another significant change in the seal of the enterprise is that company will no longer be required to conduct the procedures of seal design notification to the business registration authority before and wait for such notification to be posted on the national business registration portal before the company can use the seal. Abolishing of such procedures will have many positive effects. For example, it will simplify administrative procedures as well as reduce costs for business. However, the fact that company will be given more freedom to decide the form and the quantities of the seal, as well as the management and the use of such seals, may lead to some risk and internal dispute arising in the enterprises if the company do not have a clear and specific internal regulations on the use and management of the seal. And that is the end of the first part of business setup. I would like to move on to corporate governance. In this section, I would like to divide the amendment into 4 sections, as you can see in the slide. And now we will move on to the next part. The first amendment in the corporate governance is regard to provisions on legal representatives. As you might know, the law on enterprises 2014 has allowed limited liability company and joint stock company to have one or more than one legal representative. It is also clearly stipulated in the law that the charter shall specify the right and obligation of each legal representative. Currently, there are many enterprises have multiple legal representatives, but not so many companies actually adopted a clear provisions to divide the rights and obligation of their legal representative. Due to that, there are several shortcomings arising from such reality. For example, it may cause legal representatives to have a tendency to shift their responsibility to each other. And there are some cases that some legal representative refuse to represent the company as the defendant, leading the difficulty to the courts and causing damage to the third parties in resolving the dispute. Well, therefore, the law on enterprises 2020 has supplemented the responsibility of legal representative in such a case. To be more specific, each legal representative shall fully represent the company and take joint responsibility for any damage and any damage to the companies as stipulated in civil law and relevant laws. And moving on to the next part, according to the law on enterprises 2020, single limited liability and multi-member limited liability were allowed to issue share upon being converted into joint stock company. This is a new change in the law on enterprises 2020 compared to the law on enterprises 2014. And speaking of joint stock companies, there are several adjustments applied to this type of company. For example, a shareholder or a group of shareholders that continuously hold at least 1% of the total ordinary share will have the right to file a lawsuit against board of management and the director or the general director without the conditional of continuously holding the ordinary share for at least 6 months. Another amendment is that the supplementations of the general meeting shareholders' rights and obligations compared to the law on enterprises 2014. As you can see in the slide, there are 3 additional points, which are deciding budget or total salaries, bonus, or other benefit of the board of management and board of controllers, approving the rule and regulation of the company, the board of management and board of controllers. And finally, the final point is that approving the list of independent audit companies, choosing independent audit companies which carry out audit for the company and dismissing dependent audit when necessary. Last but not least, in these sections, I would like to present the most significant supplementation that we think will impact FDI and foreign investor greatly, which is a provision on non-voting deposition receipts. Here we will call it as NVDRs. As you may know, in Vietnam, market regulator must supervise the list of foreign shareholders and their ownership asset to factor can change company ownership from Vietnamese to foreign. If foreign investor hold more than half of the company charter capital, they hold a controlled stake. A Vietnamese company can only increase its foreign ownership limit if it's not involved in conditional sectors such as logistics, transportations, or banking. The use of NVDRs may have foreign investors to buy more share in Vietnamese company without extending their power. NVDR are meant for foreign investors who are interested in investing in a company but are prevented from doing so because of foreign ownership restrictions. Buying NVDRs is an alternative option for foreign investors as they receive the same benefits and in terms of dividend and warrants compared to those who invested in ordinary shares. The difference between buying ordinary shares and buying NVDRs are the voting rights. NVDRs holder cannot be involved in company decision making. This also have the Vietnamese company operating in conditional sectors getting a chance to reach investor abroad. Although NVDRs have been applied in several countries such as Thailand, Japan, Malaysia, it's still very new in Vietnam. And therefore, in the meantime, we will have to wait for further guidance from the government on this matter. And finally, we will move to adjustment on some provision governing a single limited liability company. The single member limited liability shall under the ownership of organizations will no longer be required to have controllers, except for the case that the company owner is a state-owned enterprise. Another point worth noting is that the single limited liability company shall have at least one legal representative who holds the title of president of the member councils or company president or the general director of the company. The law on enterprises 2020 also revised some wording of the ratio for ratifying a resolution or decision of the member councils to make it more clear, as you can see in the slide. And that's the final point of our presentation on the law on enterprises 2020. For your ease of reference, we would like to summarize 8 keynotes on this, as you can see in the slide. And in general, although the law on enterprises 2020 does not have significant changes compared to the law on enterprises 2014, these amendments are expected to give business more freedom and authority during the course of operations. And that is the end of our presentations on the law on enterprises 2020. Thank you for your listening.
Thank you very much, Ms. Thao, for your very informative presentation. So now I would like to invite all the attendees to raise questions, and we move on to the Q&A session. Now we have 3 or 4 questions already in the Q&A. So we would like to see more questions from the attendees. We have now or today we have more time for the Q&A session. Almost 30 minutes. Am I right? Do we have 30 minutes for Q&A session? So at first, we received some questions from the attendee today. We have, at first, we have one question from Ms. Ling or Mr. Ling on the, I think, on the foreign investment law. So the question is, in practice, although a foreign investor purchases only approximately 15 to 20% of the charter capital of a company in Vietnam, the local authority in certain provinces still require M&A approval or the pre-approval. Is this contrary to the regulation of law? So I think this question, I would like to invite Mr. Hong to answer this question on the investment law. So please.
Yeah, thank you, Mr. Hai, and thank you, Ms. Ling or Mr. Ling. So the question here is about the investment into the buy shares or capital in the company in Vietnam, about 15 or 20% of the charter capital of the company. Regarding this, I would like to back to my slide and show you about this. Easy for you to follow. Okay, so now as I already mentioned before, under the current law, I will explain for current law and the new law. Under the current law, if the investment in this case, I mean that buy shares in the company that conducting the conditional business line. So according to the current law, for all cases, it's required to conduct this pre-approval procedure. But now, according to the new law, only in the case that the investment, I mean the purchase of share, increase the foreign ownership ratios in that company, the pre-approval will be required. So in this case, if the foreign investor buy share in that company, that the company conduct the conditional business line, and it's make the foreign ownership ratios in that company increase from 0% to 50%, or from 5% to 50% or 20%. So under the new law, it's required to conduct this pre-approval procedure. And current law, of course, for all cases, is required to conduct. But if the foreign investor buy share in a company that not conduct the conditional business line, so the pre-approval will be required in case, for example, it's make the foreign ownership increase from under the current law, it's make the foreign ownership ratios in that company increase from under 51% to 51% or more. So it means that it will not require. And that's, so I think that the question about investment. So for the next question, Mr. Hai, I would like to back to you.
Thank you, Hong. I hope that the answer of Hong already addressed the concern of the attendee, of Ms. Ling or Mr. Ling. So moving to the next question, we have another question from Hang Le. So the question is the use of company common seal required for its transactional document to be valid during its course of operation? So I say again, is the use of a company common seal required for its transactional document to be valid during its operation, during its course of operation? So this question, I would like to refer to Thao. This is on the enterprise law. So could you please answer this question?
First So thank you for your questions. Actually, according to Article 43 of the Law on Enterprises, the seal can be used in enterprise used by enterprise in transaction as required by the law. Therefore, it can be construed that the enterprise now are given freedom to choose whether to use or not to use the seal in the transactions, unless otherwise it's stipulated by the law. And in practice, this matter is actually regulated by in many laws. For example, according to Decree 13 of the government issued in the 2020s, the state-owned companies are required to use the seal in their cost of operations. And furthermore, according to the law of on accountants, in some cases, the voucher or document or invoice shall be stamped by the seal of the company. So it depends on the transaction.
So I understand that the document Thao mentioned, does this document mention about the using of the common seal in the government authority and state-owned enterprises? And to my understanding that at the moment, even though there are several legal documents on this, but it doesn't mean that we have a comprehensive guidance for application of the new law on enterprises on 2020. Am I right?
Yes.
Okay. So it means that for the private enterprises, we need to wait for the guidance, further guidance. I hope that the comprehensive guidance, not by different regulation from different authority to cause the confusion of the enterprises on this matter. So it means that in some cases, the usage of the common seal of the companies may be still required under the new regulation, but in almost cases, the companies do not have to use or not compulsory to use the common seal for their transaction. So moving forward to the next question, I think we have totally 11 questions, but we have already answered 2 questions. So moving to the next question on the enterprise law. The question from Quang Binh: is there any difference between non-voting depository receipt and share with preferred dividend? So I repeat again: is there any difference between non-voting depository receipt and shares with a preferred dividend? So this is the new regulation of the new law on enterprises 2020. So I hope that Thao can hear clearly about the question, and please answer that question.
Yes, thank you. About this, indeed, non-voting deposition receipts and share with preferred dividends share several similar features. For example, both of these types do not have the voting rights. However, as further guidance of non-voting depositions receipts has not yet been issued, we will have to wait for the government guidance on this matter to be able to distinguish clearly the 2 types of differences between non-voting deposition receipts and share with preferred dividends.
Thank you, Thao, for the answer. And I understand there is another difference between these 2 kind of share. Is that with the new regulation, the depository receipt of share would be the company listed in the stock exchange or the public listed company can increase the capital from the foreign investor. I mean that can increase the more room for foreign investor to invest, but it does not affect the voting power inside the company. And by doing so, the government can encourage the foreign investment into some public listed company, and the barrier of the percentage or ratio under the law would be released, or would no more barrier for investment. So we move to the next question. The question from attendee Dovan Hue. So the question is, I would like to have the following question. Hope you could have. Could you share the common types of dispute that often arise in those companies which have more than one legal representative? So this matter, because I have a lot of experience in attending in dispute resolution before court and arbitration and on the company. So I would like to answer this question. Based on the law on enterprises 2014. So the first time in Vietnam, this law introduced a new mechanism for for company who want to have more than legal representative, and that is a very new thing, good thing for Vietnam, and that look like that we are trying to learn from the experience from other developed countries. But in practice, for the last 5 years of application of the law on enterprise 2014, it appears that some shortcoming and dispute happen during the operation of those companies. And in some cases, the law on enterprise 2014, it provided that the power of each representative could be stipulated in the company charter, but it hasn't. It was silent on what happened if the charter does fail to mention or fail to provide clearly on the power of each legal representative. And in fact, during the court case, when those companies attend the court case, the dispute as one party. So before the court, sometimes the two legal representatives of the company can make the different statement, and that causes the difficulty for the court to decide who can have the power, because the company charter does not mention clearly on the scope of power of each representative. So with the new law on enterprise 2020, so it mentioned, I think that is a good, it is better, and the law provide reconfirm the one principle that the charter can specifically provide for the scope of power of each representative, but it say also cover the deadlock situation, that if the charter is silent on that matter, so the representative, each representative of the company can have the full power to represent the company. So it means that without the clear provision of the scope of the representative of company in the charter, it means that each and every legal representative can sign on the document and start signing their signature with the company seal, for example, when enforce the company in all respect. But anyhow, the new law on 2020 also mentioned about a new mechanism that on the responsibility of the legal representative of the company, that they, if the chapter does not mention about the scope, specific scope of power of each representative. So in case of one of those legal representatives sign the contract or transactional document or conduct the activity in his power or her power, then that causes the damages to the company. And in such case, all of the representatives of the company will be jointly and severally responsible for the decision or activity of one legal representative. So, but it says that in accordance with the law on the civil law and other regulations. So I think that this is the ambiguity clause, and not very clear, and sometimes they cause the different interpretation of the law, the court, and maybe other people on how to implement that clause. So I hope that in the guidance on the issuing the decree by the government to guide that law, it would mention clearly about that matter. So I hope that answer would address your concern. And moving forward to the new question, again from Quang Binh. So the question is, should companies amend their charter and other constitutional documents to comply with the law on enterprise 2020? This is a very interesting question. I think that with my experiences in helping the foreign investor and foreign invested companies in Vietnam for the last over 25 years, I experienced a lot of the difficulty and the controversy between the party to joint ventures and between the shareholders in company. You know, for the last 30 years, over 30 years of application of foreign investment law and investment law after that, and enterprise law. So legal system in Vietnam changed a lot, and we learn from the other country. We learn from other, the country in the region, and also in the developed country in the world. And anyhow, the law changed from time to time. But in many cases, the joint venture foreign invested company, they disregard, or they ignore, or maybe they forget to make amendment of their constitutional document, especially the charter of the company, joint venture agreement, or maybe shareholder agreement. And then because of the controversy, because of the inconsistent between the charter of the company and also the newly issued law on investment and law on enterprises, it caused a lot of trouble for the operation. And sometimes the interpretation of that may depend on each party, depends on the benefit of each party. So I think that to comply with the new law on enterprises and new law on investment, if the charter of the company, I think that I would like to advise, is a strongly advise that the foreign investment company, especially in case of the the company with more than one shareholder, is well recommended that company make amendment to its charter and shareholder agreement on and so on regulation to comply with the new law, and by doing so, it's easier for the company to operate in the future. And it's for extension of terms to 50 or 70 years. If we fall under the exception of transfer of all asset, to the local JV partner, are there any other way to extend the business further? Do you see this question?
Yes,
So
I'm very happy because I have several questions for my part. So
okay,
now
so go on.
It's a very interesting question about extensions of the terms of 50 or 70 years. It's fall under the exception of transfers of own asset to local joint venture party. It means that Vietnamese party. So let me share with you, according to the current law, under Law on Investment 2014 and also Decree 118, there's no regulations about whether the investor have right to extend the term of projects or not. Of course, under the current law about the term projects, just provides the provisions about extension to the maximum of 50 or 70 years. Let me come back with my slide here. So the problem here is that a law has no registration for restriction for this, but in practice, for that project, it is difficult it's made very difficult to extend the term of project about the policy in practice. And according to the new law, there's already an exception. And as we have discussion with the ministries of investment and planning, so in the decree to guide for this new law, they will definitely state about the restriction for extension for these projects. So it means that actually the policy here is because previously, normally, Vietnamese party will contribute by land, golden land on that joint venture. So there's a policy that maybe that land or asset will be taken back to Vietnamese party. And so that's my answer for that. And currently do not have any regulation clearly state about restriction, but in the new law already state about restriction, and also in the decree that will be issued soon when state about that, clearly state about that restriction. Okay, I would like to move to the next. How do the from Tarrington, how do the authorities determine whether startup is innovative? According to the new law, it's already stated that the small and medium-sized innovative startup enterprises or the innovative startup investment funds will be determined under the law on support for the small and medium enterprises. And according to the current law, we have the law on support for the small and medium-sized enterprises 2017, and also Decree 38 on 2018 guidance about the definition and how to determine the innovative small and medium-sized innovative startup enterprises, as well as the innovative startup investment funds. And next, about the question from Kerry. In case a foreign company wants to invest and own shares in a local Vietnam retail company, what restrictions, if any, apply under the new law? Regarding to this, I would like to say that under the current law and the new law has no change about it. About according to the current law and under the Vietnam commitment to WTO, by now there's no restriction for foreign investment in the company, in the trading company in Vietnam. So for the detailed distribution service, is it required to apply for for the license, for the trading license, from business license, from Department of Industry and Trade, for the foreign investment company to conduct this business. Okay, so about, is there any?
So I think that we have only one more minute left. So I think that we should answer the question from anonymous attendee. What is the guideline on the e-signature? So I think this is a matter of the law on enterprise. So Thao, could you please answer the question?
That's the moment, and Ms. Thao will come back to you right now.
So you mean the questions on the guidelines?
Let me read again. The question from anonymous attendee.
Yes.
The question is, what is the guideline on e-signature?
Actually, the provisions on guiding e-signature has been provided in the law on electronic transactions 2005 and its guidance. So it's really the law of Vietnam actually have stipulated provisions on e-signature.
So you mean that we Vietnam already have the law and regulation on using electronic signature, right?
Yes.
Anyhow, that is very that is the even though that law had been issued for a while, but the application of that law in practice has some limitation. So I hope that with the issue of the new law and the effect of the new law on enterprise 2020, so the application of electronic signature would be become popular in Vietnam. So I think that that's all the question raised by the attendee. I don't know whether we missed any other question or not. I believe that we already addressed all the questions from attendee. So the time now is 11:30 now. So I would like to say thank you to all the presenter, Hong and Thao, and the representative from SBG, and also all the other attendees who spend your precious time to attend and to join us in this webinar. And if you have any further question, or if you need any assistance from Bizlink, so please contact us. And following this webinar, at the request of SBG, we will provide the PDF copy of the slide, a presentation slide, and we'll provide to all of you for your reference. And thank you very much for your attention.
Thank you very much. Thank you, Mr. Hai, and thank you for all.
Bye-bye.